I'll be back there.
You can remain seated, thank you. Folks, sorry about the delays. Some of those things are just outside of someone's control. So you can be seated. I have the memorandum that's been presented. I have obviously not had a chance to read it, but I will review it as I can. I have given it to my staff during to do the same, but he's in the courtroom, so it's going to be limited for now as well. All right, well, we finished up the day yesterday with the court working with the parties on the instructions. Counsel and defendant were present, so we have made some strides that way. But we're ready to continue the state's case. State, you ready to call your next witness? You're not here yet. Are you ready to call your next witness?
Yes,
I'm not going to bring him in if
yes,
witness isn't here.
I'm ready.
Okay. All right. So let's go ahead and bring the jury. Ladies and gentlemen, thank you for your patience. I'm sure many of you have been to funerals before, and this is obviously one I had to attend, and the services just took a little longer than I would expect. So we are here, we're ready to proceed. Mr. Slider, my next witness.
Your Honor, the state of Ohio will call Dr. Manreesha Pandey.
Thank you.
Judge, may we approach, please?
Okay.
Also, record. Do you sound swear to tell the truth, the whole truth, and nothing but the truth? So help me God. Yes, I do.
Good afternoon, Dr. Pandey.
Good afternoon.
Can you introduce yourself to the jury, please?
Yes, my name is Manreesha Pandey. I'm a deputy coroner and forensic pathologist at Lucas County Coroner's Office in Toledo.
All right, and how long have you held that position with the Lucas County Coroner's Office?
So usually, yeah, you should
It should be
just
fine.
okay.
Okay.
You don't have to leave it there.
Okay. Yes.
I suppose. How long have you held that position with the coroner's office?
I've been working here for the last 10 years at least.
All right, and where did you attend medical school?
I did my medical school in India.
All right, and did you do clinical rotations?
Yes.
And where did you conduct those?
I did those in India, and then I did them in different countries, as well as I did my pathology residency in U.S.
All right, and subsequent to your pathology residency, did you receive a fellowship position?
Yes, after that I did the fellowship.
All right, and where was that?
I did my fellowship in forensic pathology in Dayton, Ohio.
And can you explain to the jury the difference between a fellowship and a residency?
So a pathology residency, well, basically any residency is done after medical school training to get some kind of expertise in a specific subject. So I took pathology. So I did 4 years of pathology residency, and after that we do fellowship, which is super specialty of pathology. So
Which
I
is
picked
what?
super specialty of pathology, and I picked forensic pathology, and I did 2 years of forensic pathology fellowship.
All right, and do you currently hold any certifications?
Yes.
And what are those?
I'm board certified in both anatomic pathology and forensic pathology, which are from American Board of Pathology.
And where are you currently licensed to practice medicine?
I'm licensed to practice in Ohio and Michigan.
And are you a member of any professional associations?
Yes.
Can you name those, please?
I'm a member of the National Association of Medical Examiners.
Okay. And can you describe to the jury what an autopsy is?
Okay, an autopsy is an examination of a deceased person in which we do an external examination, internal examination, and we collect some fluids for toxicology examination, and sometimes some sections of the organs to determine cause and manner of death.
All right, and over your 10-year career with the Lucas County Coroner's Office, approximately how many autopsies have you performed?
I've performed about close to 3,000 autopsies.
And can you give an estimate with regard to how many of those involved blunt force trauma injuries?
I would say about 30%, 30 to 40% would be blunt force trauma.
So a significant amount.
Yes.
All right. And during your career, approximately how many times have you testified in court?
About 28 times.
And have you been qualified as an expert witness in each of those circumstances?
Yes.
And has that occurred in Lucas County Court of Common Pleas?
Yes.
I'm going to approach you with what's been marked as State's Exhibit number 15. Can you please review State's Exhibit number 15?
Did you say 20 times? 28.
28.
Thank you so much.
Doctor, do you recognize State's Exhibit number 15?
Yes.
And is that a copy of your curriculum vitae?
Yes.
And does that exhibit fairly and accurately represent your training experience and professional background?
Yes.
Your Honor, at this time the State would move to admit State's Exhibit number 15 into evidence.
Ms. Ryan, have you had a chance to review the document?
Yes, no objection.
All right, have you received? Thank you.
I'm also at this time, Your Honor, going to move to qualify Dr. Pandey as an expert witness in forensic pathology.
Care to order the witness, Ms. Ryan?
No, Your Honor.
All right. Any
No
objection?
No objection.
She was declared an expert in forensic pathology.
All right, Doctor, did you have occasion to perform an autopsy on Daniel Vasquez?
Yes.
And where did that autopsy take place?
It took place at the Lucas County Coroner's Office.
And do you recall the date that the autopsy took place?
Yes, it was on 5th February 2018.
And prior to his arrival at the Lucas County Coroner's Office, did he receive medical treatment at Mercy St. Vincent Medical Center?
Yes.
And was that where he was pronounced deceased?
Yes.
Doctor, I'm going to approach you with State's Exhibit number 16. Please review State's Exhibit number 16.
Yes.
Doctor, can you describe for the jury what is contained within State's Exhibit number 16?
Exhibit number 16 contains the case summary, the coroner's verdict, the autopsy report, and the toxicology final report for Daniel Vasquez.
All right, and with regard to the case summary and coroner's verdict, did you author those particular reports?
Yes.
All right. And are those reports, as well as the toxicology report associated with the autopsy, generated in the ordinary course of business of the Lucas County Coroner's Office?
Yes.
Your Honor, at this time, the State would move to admit State's Exhibit number 16 into evidence.
No objection, Judge.
All right, thank you. Will be received.
Doctor, I'm also going to approach you with some photographs in a moment here related to the autopsy of Mr. Vasquez. Doctor, I'm going to show you State's Exhibits number 17 through 27. Please examine those for me.
Yes.
All right, Doctor, State's Exhibits 17 through 27, are those photographs that were taken during the autopsy of Daniel Vasquez?
Yes.
And do each of those photographs appear to be a fair and accurate representation of Mr. Vasquez's condition at the time of the autopsy?
Yes.
And does it appear that any material alterations or deletions have been made to any of those photographs?
No.
Your Honor, at this time, the State would move to admit State's Exhibits number 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, and 27 into evidence and request permission to publish them to the jury.
So I know there was pretrial objection. That objection is noted. Is there anything further?
No further objection. Still object to the standing objection.
All right, thank you. The objection is noted that they will be received and allowed to publish. Go ahead.
All right, Doctor. I'm going to use a laser pointer. I'm going to stand over on this side. That way I'm not in your way. We'll start with... All right, so this is State's Exhibit number 17. What are we looking at in this particular photograph?
Exhibit number 17 is a photograph of top half of Daniel Vasquez as he was received at the Lucas County Coroner's Office.
All right, and within the photograph, right in this region, I'm circling with the laser pointer. Is there anything of note?
Yes.
And what is located in this section of his face?
So on the right side of chin of Daniel Vasquez, the one that you pointed, there is a bruise on that area.
All right, State's Exhibit number 18, what are we looking at?
Exhibit number 18 shows the face, what is called as identification photograph of Daniel Vasquez.
Next exhibit is State's Exhibit number 19. I'm going to use the laser pointer again and circle around the chin. Can you describe for the jury what we're looking at here?
Exhibit 19 shows Daniel Vasquez's chin and the lower lip area. You can see that there's bruise in both those areas.
All right, State's Exhibit number 20. What are we looking at here? Again, I'm using a laser pointer to circle for the jury.
Exhibit number 20 shows the lower lip of Daniel Vasquez and it's basically been reflected down with the forceps, and you can see the purple bruise.
All right, and that's right here inside the lip.
Yes.
All right, State's Exhibit number 21 is next. I'm going to circle a segment, which it is on the left side of his head. Does that appear to be a scar that's been stitched up?
Yes, that's a surgical incision which has been closed.
And are you familiar with this type of surgical incision?
Yes.
And can you describe to the jury what type of procedure would be used that would create that type of scarring?
So that is what is termed as a left craniectomy scar, surgical procedure in which basically what happens is we make an incision and you reflect the skin and you go in to relieve pressure from a lot of blood or anything, whatever is in there, to basically go in and do a surgical procedure to evacuate the blood on the left side. So in this case it was on the left side and they did a left craniectomy. And the left bone flap was absent in that area.
Now, is the purpose of this procedure to assist in relieving stress from brain swelling?
Brain swelling and hemorrhage and any kind of clots.
All right, the next exhibit is State's Exhibit number 22. Is this just another viewpoint of the craniectomy scar?
Yes.
Next exhibit is going to be State's Exhibit number 23. What are we looking at here, Doctor?
Exhibit number 23 shows Daniel Vasquez's left side again, and here you can see a lot of blood in under the skin and over the bony area, as well as this is basically corresponding to the left craniectomy. That's the surgical site. So that is what it's showing. A lot of blood in that area on the left side of Daniel Vasquez's head.
State's Exhibit number 24. What are we looking at here, Doctor?
So this exhibit number 24 shows top of Daniel Vasquez's head, and here you can see the area which is being pointed by the laser pointer, a dark purple red area which is blood clots, and that area is absent. There is no bone in that area, and that's showing that the underlying brain and it's basically the brain is covered with hemorrhage. And you can also see on the top of the rest of the bony area on top of the head, there's blood. So it's basically subgaleal hemorrhage. We call it blood under the scalp.
Doctor, is another term for this particular type of hemorrhaging subdural hematoma?
Subdural hematoma is under the bone.
Under the bone? Okay. All right, so let's go up to State's Exhibit number 25. What are we looking at here?
Exhibit number 25 shows Daniel Vasquez's brain. The bone, whatever portions of the bone was there has been removed, the calvarium we call it, and you can just see now that the Daniel Vasquez's brain is visible, and you can see that it is covered with blood.
Doctor, based upon your view of Mr. Vasquez's brain in person during the autopsy and through the view of this particular photograph, what can you tell us about the brain? Is it swollen? Is it normal size?
So the brain appears quite deformed because of the surgical procedure on the left side. On the left side, you can see swelling of the brain. On the left front, that's where the pointer is.
Where I'm pointing with the laser pointer?
And you can also see patchy areas of subarachnoid hemorrhage that is covering the brain, so hemorrhage, blood covering the brain. And on the left side, you can also see subdural hemorrhage. So that's a reflection of the dura, which covers the brain.
It would be easier if you pointed that out with the
Yes.
pointer.
Can I do it on this, or?
I'm not sure if that would work or not.
It hasn't been working, so.
Hasn't been, okay.
I'm going to hand this to you, just use this part here, and I'll give you the laser pointer.
So top of the head is showing all these areas of hemorrhage, that's subarachnoid hemorrhage. This is the reflection. So you had seen this was covering the brain on the previous exhibit. So this is the reflection. This shows subdural hemorrhage right here.
Doctor, let's go to State's Exhibit number 26 now. Mr. Vasquez's brain.
Yes.
And can you use the laser pointer to guide the jury through some points of interest with this particular exhibit?
Yes, this is basically this is Daniel Vasquez's brain. You can see the underside of his brain. The area which is I'm pointing right now with the lots of hemorrhage, it's on the right side, and this is the left side, the opposite side. So you can note that there's on the base of the brain, there's what is called as hemorrhagic clots, and it's bruising of the brain. So it's on the left front, left temporal, and then there's bruising of the brain. Sorry, that's the right front, right temporal, and then the left left temporal and left frontal brain. So this is the side which had the surgery, the opposite side, and this is the side which is on the opposite side. That's the right side.
Let's go back. Doctor, based upon this particular image, are you able to determine whether Mr. Vasquez had a stroke at any point in time?
These are not the photo. This is not the photograph which is showing us the stroke.
Okay, but he did have a stroke?
He did have evidence of a stroke, yes.
All right. And I'll go to State's Exhibit number 27. And again, if you could use the laser pointer to guide the jury through points of interest.
So once again, the previous photo was about the base of the brain. This is the right side of Daniel Vasquez. You can see there's more hemorrhage here on the right side. So this is all, the brain has been damaged, so there's bruising in the brain, and that's what this is showing.
And would that be consistent with blunt force trauma on the right side of the head?
Yes, it will be consistent.
Now, Doctor, you talked about earlier with reference to defining an autopsy, manner of death and cause of death. So let's talk about manner of death first. We'll talk about manner of death first. Can you describe manner of death for the jury?
Yes. So manner of death is there are different manners which are natural. If you die of a natural disease, there is suicide if it's a self-inflicted trauma, homicide if it's as a result of another person's action, the death, and then there is accident, which is motor vehicle crash or any kind of drug overdose, and then there's undetermined when we are not sure how that happened. Like it could be the difference between a suicide or accident versus natural.
Now we also have cause of death, right?
Yes.
And so is that a more definite, I guess, definitive explanation of what death would be, as opposed to manner, or is it a little more broad?
Okay, so the cause of death actually is what the person died of, and the manner of death is how they died. So for instance, if it is, like in this case, if there's blunt force trauma to the head, so that is what they died of. That was their reason for dying. And how did it happen? So if they had just had a motor vehicle crash and got a blunt force trauma, it will be an accident. If they're hit, then it's a homicide. If they jumped, then it would be a suicide. So manner would depend on how that cause of death happened.
All right, doctor, and based upon your autopsy, did you determine a manner of death in this case?
Yes.
And what was that?
The manner of death was homicide.
And did you also determine the cause of death?
Yes.
And what was that?
It was complications of blunt force trauma to head.
And is that information contained within your report, which has been marked as State's Exhibit number 16?
Yes.
All right. Now, Doctor, at the time of his death, Mr. Vasquez had a heart condition. In your opinion, did his heart condition play any role in his death?
No, he died of complications of his blunt force trauma to head.
All right. And he also had a combination of alcohol and drugs in his system. Did that contribute to his death?
No.
All right. And are your opinions and findings based upon a reasonable degree of scientific and medical certainty?
Yes.
Doctor, we have a situation where 911 called at 12:47 a.m. approximately. First responders begin treatment at approximately 12:58 a.m. And he arrives at the hospital and starts receiving critical care at approximately 1:18 a.m. With surgery performed shortly after 2 a.m. Is there anything that, in your opinion, could have, if it had gone a little bit faster, that would have changed the ultimate result here? Or were Mr. Vasquez's wounds fatal from the time he received them?
So I don't treat anyone, so I would not be able to comment on that, whether he could have been saved or not. But his injuries at the time of autopsy were fatal because he died of them.
Okay. No further questions, Judge.
Thank you. Cross-examination. I'm sorry, you're welcome to move the lectern where you want.
Sure. Good afternoon, Dr. Pandey.
Good afternoon.
You work for the Lucas County Coroner's Office, correct, ma'am?
Yes.
So you're employed by the county, correct, ma'am?
Yes.
Okay. And your county pays your pay, correct?
Yes.
When you had this autopsy, can you tell me who was present at the autopsy?
I had an autopsy technician and I had scientific
I'm sorry.
investigation.
Judge, if I may just...
Sure.
Thank you. Please go ahead.
I had an autopsy technician as well as a scientific investigation unit from TPD, Toledo Police Department, Jeff Jackson.
And Jeff Jackson's from where, ma'am?
Toledo Police Department.
Okay. So you had the police there with you when you conducted the autopsy?
Yes.
You see on the exhibits that were presented to you, ma'am, the coroner's summary of death and the report of the autopsy of Mr. Vasquez.
Yes.
Okay. And you testified, ma'am, that he also suffered a stroke, correct?
Yes.
Can you please review those documents and tell me if you mentioned any of that, and that you mentioned that there's a stroke in those documents that it's mentioned in there?
It's mentioned on page 3 or 4 of my report of autopsy under nervous system.
Okay, and that's where it says right basal ganglia have a 1x1/2 inch soft dark brown area, correct?
Yes.
You didn't say it's a stroke.
No.
Aren't those highly dangerous? Aren't they highly deadly strokes?
Strokes can be deadly, yes.
But what type of stroke was this?
This is probably either a hypertensive stroke or atherosclerotic stroke.
Isn't it a brainstem?
Atherosclerotic. Thank you.
Isn't it a brainstem stroke?
It's not a brainstem, it's a basal ganglion stroke, so it's in one of the halves of the brain.
Do you know what the chances of survival for individuals that have stroke such as this, brain stroke such as this?
I don't know the chances of survival.
If I tell you the chances of survival were 13%, would I be lying or would I be incorrect?
I would not know.
Do you know what the chances of survival for an individual that comes in to the hospital with a subdural hematoma?
Most of the subdural hematomas, which I performed the autopsy on, they've all died.
Right, but the people there's a large number of individuals each year that go into hospitals with subdural hematoma. Do you know what the numbers of survival for individuals that come into the hospital with subdural hematoma?
I don't say them, so I don't know. I've not reviewed that.
If I tell you 75%, up to 75% could be saved, would that be an incorrect number?
I would not know.
Judge, I think we're on Exhibit C for the defense.
Yes.
Yes. This is just one of the pictures of the autopsy. Okay. May I approach the witness?
You may.
Okay. I'm going to show you, Dr. Peter, can you tell me what that document is?
That's Exhibit C, or what's it? C?
And is that,
And it's,
I'm sorry, go ahead.
yeah, it's a cut section of Daniel Vasquez's brain, in which we can see that there is a little bit of hemorrhagic area.
Okay. And was that part of your autopsy findings, ma'am?
Yes.
Now, may I move to admit and publish to the jury this exhibit?
Any objection?
No.
COB received and can publish. The associate's welcome to help you do that.
Thank you, Judge. That's probably better tonight. Is that defense exhibit C? Is that picture number 15 you said, Dr. Peter?
Exhibit C, yes.
Okay. And what I want you to bring your attention, is this the area where the brain stroke happened right here? That round spot?
It looks like the hemorrhagic area, yes.
And that's what you put in your report of the stroke that Mr. Vasquez suffered?
I actually don't recall another. Is there another photograph?
Well, this is the photograph we're talking about right
Okay.
now.
So this must be it.
Yeah. Does it look like it?
It looks like a hemorrhagic area to me.
And why couldn't you rule, Dr. Pandey, that this also caused the death of Mr. Vasquez, considering that this is a dangerous situation with the brain stroke?
So basically what happened in Daniel Vasquez's case is he had sustained trauma, and he went and got some kind of hemorrhage and edema and all sorts of changes from the trauma. And most likely the stroke and everything is, all the things are happening in the brain, right? So that's why the cause of death was determined to be complications of blunt force trauma to the head. So these are all sequelae coming from the trauma.
But you can't sit here with certainty, Dr. Pandey, telling me that whether it was the subdural hemorrhage or the brain stroke that actually caused the death of Mr. Vasquez.
The cause of death for Daniel Vasquez, Mr. Vasquez, was, it started from his blunt force trauma to the head. So the subdural, the subarachnoid and everything, and the cerebral edema, the pressure applied on the brain, and subsequently he had surgery done, and all those things, that's where it started from. So it's the complication. So stroke is likely as a result of one of the complications.
But couldn't that stroke, that brain stroke right there we see, couldn't that have started before the fight or before the incident, before the blunt force trauma?
It could have, I don't know.
Okay, thank you. I'm sorry, okay. Dr. Pandey, can you tell me what that is on the deceased's arms right there?
On the arm twist, on one of the arms, you can see there is some kind of bruising.
Some kind of bruising?
Yes.
Okay. Do you know what that was from by any chance?
It was just bruising. And there are some intravascular things happening on the, like IV marks on the right
On the right side
elbow
there?
area, the other side.
But this is in, this is around his muscular area, by his, where his muscles are, right here and right there. You don't know what that's from, that's just some bruising?
That's bruising in the soft tissue
Okay.
on the right side.
So you could take that off, just, all right, thank you. And again, doctor, do you basically see the individual after all the medical procedures have been conducted, correct?
That's correct.
So basically you evaluate the deceased, correct?
Yes.
Okay. You don't know whether any procedure at the hospital was done properly or not. You can't tell by your autopsy, correct?
No, I would not be able to comment on that.
Were you aware that he had 60-90% stents in his arteries?
Yes, he had coronary artery disease.
We've seen some pictures in reference to the bruising on the lips and the jaw. You didn't find any broken jaw for Mr. Vesco's, did you?
No, I did not find it. No.
You were aware that he had multiple seizures while he was at the hospital, correct, ma'am?
I don't recall reading that, but he must have had with a head trauma.
Were you aware that he was on seizure medicine before?
I was not aware that he was on seizure medication before.
Now, do you know the procedure that was conducted at the hospital, Dr.?
For Mr. Vasquez, it was left craniectomy. That's what the remnants of that is what I saw at the time of autopsy.
Okay. And can you please describe to the jury what that is, the craniotomy? I'm sorry for butchering the medical terminology.
Okay, so left craniectomy is a procedure in which left side of the skull, the bone is removed. So we make an incision, which we saw before, and we remove the bone to relieve pressure and to evacuate the blood or anything which is happening over there.
And is that conducted with some kind of catheter that is put into the brain once the bone is removed in order to allow the excess blood to be drained?
I'm not sure how it is done.
And you indicated, doctor, that it was the right side of the brain that was hemorrhaging?
Yes, there was hemorrhage in the right side also.
Okay. Do you know whether alcohol consumption can cause a subdural hematoma?
Just alcohol consumption on its own, no. but alcohol consumption can cause, it depends on how long you've been consuming the alcohol.
But it's possible for it to cause subdural hematoma.
It can't cause the subdural hematoma. You need some kind of injury to cause the subdural hematoma.
Some type of injury.
Yes.
Could a fall to the head cause that alongside with alcohol?
Yes.
Doctor, if somebody's punched in the head 6 times, can that cause a subdural hematoma?
Yes.
And if somebody has a traumatic brain injury, can that result in seizures?
Yes.
And if somebody suffers a brain injury, can that create conditions that could lead to a stroke?
Yes.
With regard to the seizure medication, you have no evidence that Mr. Vasquez was previously prescribed with seizure medication prior to you receiving him for his autopsy, do you?
I don't have any history of that.
All right, and you don't have any history of him having any prior brain injury prior to this particular incident, do you?
That's correct.
No further questions.
Just one follow-up, Judge. Dr. Peter, in your evaluation, you did see a toxicology report, right?
Yes.
And didn't the toxicology report show that there was Keppra, the seizure medicine that was in his system?
Yes.
Thank you. Nothing further.
All right, thank you, Doctor. You step down.
Excuse.
Yes, please. Thank you. All right, if I can see counsel. All right. Ladies and gentlemen, we're at a technical procedure of the trial that I have to excuse you for a few moments while we take care of this. Ask you held outside your hearing. It should take 10 to 15 minutes, knowing court time, let's call it 15 minutes. And right now I'm showing it's 2:40, so it'll be closer to 3 o'clock, maybe 5:03 that we'll have you back into the courtroom. If you can just stay back in the jury room or close in the hallway, that would be fine. We'll see you in a few minutes.
All rise for the jury.
All right, so the state is not calling further witnesses, and are you going to rest?
Yes, you're arresting.
Thank you. Then, Mr. Ayad,
Yes, Your Honor. The defense moves at this time, Your Honor, for a Rule 29 motion for a directed verdict as to the charge of murder and complicity to murder, Your Honor, and felonious assault. We feel that, and complicity to felonious assault, and that, Your Honor, we feel that no reasonable jury could come to the conclusion that there is the evidence beyond a reasonable doubt. I feel not even a preponderance of the level standard, but beyond a reasonable doubt in this criminal matter to show that this particular defendant was not provoked to commit the crime. The charge that he's charged with, Your Honor, under count 1 murder is the the charge itself, Your Honor, with the, it says no one shall cause the death of another as a proximate result of the offender's committing or attempting, commit an offense of violence, to wit, felonious assault that was a felony of the first or second degree, and that was, and this is the important section, not a violation of section 2903.03 or 2903.04 of the revised code, in violation of 2903.2b and 2929.02 of the Ohio Revised Code for murder. Quite simply, Your Honor, 2903.03 is voluntary manslaughter. We feel that we meet all the elements at this particular stage with the prosecution's case for this issue of that they could possibly meet the elements of involuntary manslaughter, which is 2903.04 and 2903.2, but they cannot prove the elements of murder, Your Honor, because there's clear indication, and I think it was very obvious from the videos that were presented, from the testimony of Ms. from the documentation that was been presented that this individual, this defendant, was provoked. The statute and the spirit of the statute, Your Honor, is exactly for situations such as this, where someone is just simply provoked into committing the crime. Even though I feel there's even, it goes to another level of 2.903.04 as to there's no intention to kill, but that's an issue of course still for the jury to decide on. But at this stage, there's clear indication, Your Honor, that this defendant was provoked into doing the conduct that he did at that particular evening on January 31st. I think no reasonable jury, Your Honor, is going to find this particular defendant guilty of murder or complicity to murder under these set of circumstances. As to complicity, again, it's the state's position that he's the one that basically done the knockout punch and ended up killing Mr. Vasquez. We haven't seen any indication or any evidence saying as to the complicity where he agreed with someone else or coerced someone else or told someone else or agreed with someone else to cause the death of Mr. Vasquez. Under this set of circumstances, Your Honor, the murder charge should be dismissed. There simply is not enough evidence to show that this defendant did not do it at the cost of provocation and under those set of circumstances.
All right, thank you, sir. State.
Well, Judge, as the state argued yesterday, the defendant has brought the complicity angle into the case on his own through his own theory of the case. One of the issues that he's attempting to allege is that the state cannot prove causation. And one of the main, and he even did it on the cross-examination of Dr. Pandey, he addressed it during the video, that there's another individual that threw Mr. Vasquez to the ground on numerous occasions, and that could have been what caused the subdural hematoma. He's missing the most important part of the complicity statute and language, which is aid or abet. So it doesn't have to be a prior plan, he doesn't have to solicit, he doesn't have to conspire. Conspiracy is actually a completely separate code section. All he has to do is aid or abet. And through the video, we see clearly that Mr. Wimpey strikes Mr. Vasquez in the head 6 times. All right, so he's clearly engaged in assaultive behavior. Now, with the issue of provocation, the problem with the defendant's argument is the provocation has to rise to the level of fear of imminent danger or harm, and that's just not there. The initial confrontation between Mr. Richter and the defendant, Mr. Richter simply uses words. At the time that he goes and grabs the pool stick, rather than if Mr. Wimpey was truly afraid of what was going to happen, he wouldn't have walked across the bar to engage him, which is exactly what he did. And in that circumstance, the state would submit that Mr. Wimpey was engaging, just made a decision to engage in mutual combat at that point. It's not a defense issue. So provocation is not an issue. And additionally, the most importantly is Mr. Vasquez did absolutely nothing to provoke Mr. Wimpey. He never threw a punch at Mr. Wimpey. The only thing he ever did was try to get Mr. Wimpey off of Mr. Richter at times when Mr. Richter was on the ground and Mr. Wimpey was standing over top of him. You know, there's one clear instance where he has his arms around Mr. Wimpey from behind because Mr. Richter's on the ground and Mr. Wimpey's standing over top of him. Now, you know, defense counsel can articulate that particular moment in time however he wants to. You know, we clearly have completely different views on what's on the video, but Mr. Vasquez did absolutely nothing to Mr. Wimpey to warrant being punched in the head as many times as happened. And especially with regard to the last incident which led to the last punch. You know, the problem that we have here is defense counsel keeps trying to break this up into multiple fights, and even through his most recent pleading tries to put words in my mouth saying that I've conceded there's 3 separate fights. I've never conceded that point. What I've said is this is a continuing course of conduct. Okay, and the continuing course of conduct is this occurred within a span of approximately 20 minutes. You can break it up into 3 segments, but it's not 3 separate fights. It's all the same continuing course of conduct. And in the last segment of that course of conduct, is when Mr. Richter throws beer bottles at the truck. He's causing harm to property, not to persons. And at that point, once Mr. Massad and Mr. Wimpey exit the vehicle and chase Mr. Richter back into the bar, the danger has flipped. And now the person who's in fear of imminent danger is actually Mr. Richter, because the aggressors are Mr. Massad and Mr. Wimpey. And, again, we'll address this when we get into the self-defense arguments, etc. But the bottom line is, all the state has to do is make a prima facie case that the defendant committed the offense of felonious assault, which was the proximate cause of Mr. Vasquez's death, and we've absolutely done that through video evidence and through testimony of Dr. Pandey. And in terms of the Rule 29 motion, legal precedent states that you're supposed to view the evidence in light most favorable to the state, and at this point, the state has made a prima facie case. Defense counsel is completely incorrect that we've not even met a preponderance of the evidence. That's an absurd argument, Your Honor.
Judge, just real quickly.
Yes, sir, go ahead.
And even if we buy the prosecutions and you agree that we will even give him causation if at this stage, Your Honor, say that he did cause the death of the deceased, that still does not take away the provocation aspect. Even assuming he caused causation, even assuming this defendant killed the deceased, the fact of the matter is he was still provoked to do it. That's what that 2903.3 is about, Your Honor. He says it was just words. I strongly disagree. It's not just words, Your Honor. It's the actions of Mr. Richter. It's him grabbing a weapon on 4 different occasions. It's him coming in his face. It's him coming in his space. That's just very much different than just words, Your Honor. And we have to take the defendant as he was thinking at that particular time. We've seen 3 individuals step up to him, come across, 2 of them from the bar, step into his space, into his area. He's looking at 3 individuals that he does not even know. He's never seen them before in their life. And one of them is just ramping on about him, already emboldened, cussing at him numerous times. This was not just the words. He then grabbed a stick. He's the one that started, grabbed the stick and the weapon, Your Honor. So he was provoked. I think any reasonable juror is going to find that he was provoked. And that Mr. Vasquez does grab him. That's an assault. That's an unwanted touching. He goes to grab him. He doesn't know this individual. Not only grabs him, he comes and bear hugs him, attacking him. And then at one time you see Mr. Vasquez punching Mr. Massad. But that's besides the point. Regardless if this defendant was concerned, was afraid of whether it be Richter or Mr. Sharp or the deceased Mr. Vasquez, the fact is he was concerned. He doesn't know these individuals. They're coming in his space. And that's what provoked him to act as the way he did. And lastly, Your Honor, it was not just it was an assault. I strongly feel when they threw those bottles against the truck. You heard the testimony of Ms. Wolf, where she clearly said that she was afraid that bottle was going to go through the glass and hit her. She was concerned for her safety and concerned in bodily injury. And that's all we have to show, Your Honor. So I ask this court to dismiss the murder and complicity of murder.
Thank you, Mr. Spicer.
I have a difficult time putting together arguments against Mr. Ayad because it seems like even if I point at the light and say that the light's on, he's going to say that it's off. And it doesn't matter if what's on video, he's articulating completely different positions. I mean, if you look at this most recent pleading, the last sentence, within minutes of the alleged knockout punch, the defendant was surrounded and threatened with pool sticks and swung at with bottles. Beer bottles were never swung at Mr. Wimpey. He's adding facts that don't exist. Okay?
You'll have an opportunity.
The beer bottles were never swung at him. Okay? Pool sticks were never swung at him. All right? When you watch the video, the time when he's surrounded, Mr. Richter breaks away from the grouping to go grab the pool stick. The other 2 gentlemen, Mr. Vasquez and Mr. Sharp, step back. And that's when Mr. Wimpey walks around them. And if he's truly concerned about what they're going to do, he's not going to keep them out of his view. But he's not concerned about them because they're not a threat. He's going to engage Mr. Richter because now it's time to fight. It's not time for self-defense, it's time to fight. This is a mutual combat situation. And if he was truly in fear of danger, after the first time that he knocked Mr. Vasquez to the ground, he wouldn't have turned his back to everybody and walked up to the bar and taken a sip of his drink. That's not evidence of somebody that's in fear of imminent danger. That's somebody that's satisfied that they just knocked somebody to the ground with a 4-punch combination. And the other issue that you have is the second time there was a pool stick, Mr. Wimpey never even saw it because he's too busy punching Mr. Vasquez. The only contact Mr. Vasquez has with Mr. Wimpey, other than trying to get him off of Mr. Richter, is Mr. Vasquez's face coming in contact with Mr. Wimpey's fist. That's it. The state has made a prima facie case for murder. It's made a prima facie case for felonious assault. The provocation just isn't there, Your Honor, despite defendant's arguments.
Just as he said, I could tell that I can say something. He can say something. I could say I was like to do the same for him. I mean, that's not true. The video very clearly shows when he was back at the bar, he grabbed a beer bottle and swung it at him. That's when he kicked him to keep the danger away from him. Whether we define swinging the pool stick is a different. At one time he was he can be identified as swinging. Maybe not directly within his vicinity at that particular moment, but he was swinging at one time. But more importantly, there was a beer bottle that was swung at him very viciously by the bar area.
All right, thank you. What we're talking about here is Ohio Rules of Criminal Procedure, Criminal Rule 29. It is entitled a motion for acquittal. Sometimes it is referred to as directed verdict, but in this instance it's a motion for acquittal, and this is under 29A. The court, on a motion of a defendant, after the evidence on either side is closed, shall order an entry of a judgment of acquittal of one or more offense charged in the indictment if the evidence is insufficient to sustain a conviction of such offense. The standard for the judge is to review the evidence in a light most favorable to the party against whom this motion is being made. That would be the state. So if I view the evidence in a light most favorable to the state, then what I have to look at is, have they met their burden in a prima facie case and the burden of production, producing evidence as it relates to each and every element of the offenses. The offenses as charged in the indictment are reflected in 2 counts. Count 1 is a charge of murder under the B section, and count 2 is a charge of felonious assault. I'm going to start with the felonious assault first, simply because the B murder, count 1, requires the proof of a felonious assault to begin with. So we'll start with felonious assault, of which the elements are that on January 31st of 2018, that was established, at least viewing the evidence in a light most favorable to the state, by multiple witnesses in Lucas County, Ohio. It was established with the address given that brew house is located in Toledo, Lucas County, Ohio. It knowingly caused. The evidence shows, if interpreted by the jury to be such, and that's what I'm required to look at right now in a light most favorable to the state, would the jury believe that there was a knowing act by Mr. Wimpey? The video evidence shows whatever you want to interpret it to be, but that it appears that there is a striking motion, can be argued to be knowingly. The elements that the court is not going to get into because that is more for the argument of counsel at closing. Nonetheless, the court does find that the elements of knowingly were presented, at least in a light most favorable to the state. Cause, as a result, there is evidence produced that shows that a punch by Mr. Wimpey caused, and then serious physical harm. Serious physical harm is such duration that can cause permanent incapacity. In this case, it did actually have the testimony from Dr. Pandey that it was the cause of death, the blunt force trauma caused by another. Therefore, and then the other person being Mr. Vasquez. So the state has met its burden of production as to each and every element of count 2, that being the physical or the felonious assault. Now take that into count 1. And it's the same date, which was established. Lucas County, Ohio, brew house is in Toledo. Cause of death of another. Mr. Vasquez did pass away, so we know he died. as a proximate result. Evidence was presented to support that this was the proximate result of blunt force trauma caused by Mr. Wimpey and a punch to Mr. Vasquez in committing or attempting to commit the offense of felonious assault, which I just covered moments ago, which has been established in a prima facie case in a light, viewing the evidence in the light most favorable to the state, that a felonious assault has occurred. The felonious assault, the court takes judicial notice, is a felony of the second degree, and it is not based on voluntary manslaughter in 2903.03 or involuntary manslaughter in 2903.04. So the state has met the elements for each charge. The motion for acquittal is denied. Find that the state did meet its burden of production. The objection will be noted by counsel for appellate purposes. That being said, the case is now with the state. Mr. Ayad, I understand that one of your particular witnesses is available for tomorrow, but that you do have a witness that you are ready to call yet here today, correct?
I believe he's outside.
Right. And that's what I want to give you the opportunity to go ahead and check and verify. With that, I'll give counsel a few moments to use the restroom, and then as soon as you're back in and verify that the witness is ready, we'll bring the jury back in to call the witness.
Thank you, Judge.
Ladies and gentlemen, welcome back to the courtroom. That was a little bit closer to the time I like to keep it on. First, I'm going to ask Mr. Spryzak a couple quick questions. Sir, do you have any other witnesses?
I do not, Your Honor, no.
And is the state now resting the case?
Yes, Your Honor.
All right. So that was done outside of hearing formally in front of you now. The court has received the exhibits as presented by the state. We've made those rulings. We've ruled on any other technical procedure that we have to do outside of your hearing. And we are now ready to defer to the defense. Mr. Ayad, ready to put on the defense case?
Yes, Your Honor.
And you may call your first witness.
Thank you.
Just come right this way, please. Raise your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good afternoon. Can you please state your name for the record?
Daryl Ray,
Mr. Ray, where are you employed at, sir?
Toledo Fire Division.
What's your position at the Toledo Fire Department?
I'm a lieutenant of force.
How long you been with the Toledo Fire Department, sir?
29 years.
I want to take you back, sir. Do you remember an incident on January 31st at the city of Toledo at the establishment of Brujas Bar?
Yes.
Okay. Can you tell me, sir, how were you notified to come to that location?
Through the 911 system, they direct us to our dispatch and we're sent to the scene for first responder.
Okay. And did you, do you know what time you ended up arriving at Brujas, sir?
It was dark out, so it was in the evening.
Okay. Was it past midnight, I think?
I don't think it was. It might have been a little before. Not quite sure.
Can you describe the scene, sir, when you arrived?
There wasn't a lot of people in the establishment, from what I recall. Just a few people still there, and then there was a gentleman lying on the floor, and he's the one that was injured that we were going to be treating.
Okay. And when you arrive on the scene, sir, is it your job normally to find out kind of some background facts of what took place?
Exactly.
Okay. And did you inquire as to what took place of the person lying on the floor?
Yes, but I think somebody was already kind of telling us when we got there what happened, so it all happens all at the same time usually.
What did you learn happened, sir, to Mr. Vasquez?
That there was a fight of some sort, and that I just recall them saying that this gentleman tried to break up a fight and he was possibly knocked down. I mean, they didn't say that, but I'm assuming he's laying on the floor, and And then she did say, I don't know if she was a barmaid or what, but she did say that he was kicked in the head, and they did see that.
Okay. And is it your policy, sir, to write a patient care record upon evaluating a certain situation when someone needs some medical attention?
Yes.
Judge, may I approach the witness? I'm handing you what's proposed as Defendant's Exhibit A. Can you please look at that document and tell me whether, are you familiar with that document, sir?
It's been 10 months, so I mean, you know, I'm familiar with the document, yeah.
Okay. And you see on the third page, or page 91, sir, where it says the personnel page there? In the middle of the document. I apologize.
Yeah, I see
it's kind of
that.
small writing. Okay.
Yes.
It says that basically you were Daryl, Ray Daryl. That's you. That's Lee, correct, sir?
Right.
Okay. And there's other individuals, Richard Doran and Gina Chewbacca, right?
Right.
Okay. And sir, if you could please turn to page 90 and the second page of that report. And you authored this document, right, sir?
Yes.
Judge, I'll move at this time to admit this exhibit, Defendant's Exhibit A.
Safe position.
I object for the same reasons I did yesterday.
He authored it, Judge.
Let's have an argument at sidebar, please.
Just give me 1 moment, please. Thank you, sir. I'm ready.
Sustained. Go ahead.
Mr. Ray, can you tell us, please, that you didn't write in the report that this individual was trying to break up a fight, correct?
Correct.
And you indicated that you weren't sure how many times he was kicked, this individual, right, when he was down?
Correct.
And he was breathing when you see him, sir?
Yes, he was, he had snoring respirations, what we call snoring respirations, like he's sleeping, but couldn't be aroused. So he was breathing, and then, of course, with that type of breathing, he's going to need assistance. We helped him with that.
Okay. All right. Nothing further.
All right, thank you. Cross.
Yes, thank you, Judge. Good afternoon, Lieutenant.
Good evening.
I want to approach you with State's Exhibits 7 and 8. When I unhooked my computer for window research, so I can't project.
Okay.
So we're going to have to do this the old school way. All right, State's Exhibits 7 and 8. Those were taken after Mr. Vasquez was removed from Brujas. Do you recognize that section of the bar?
Yes.
And was Mr. Vasquez bleeding in his mouth at the time that he was being treated?
That I don't know. I was not close enough for that.
Okay. Does that appear to be blood on the floor?
Yes.
All right. And is that the area where Mr. Vasquez was laying when he was being treated?
Exactly.
Okay. And Mr. Vasquez never regained consciousness while he was being treated by you and other first responders, did he?
That's correct.
But he was breathing on his own, correct?
That's correct.
And he never stopped breathing?
That's correct.
But you guys did assist him with breathing as part of your treatment, is that accurate?
Yes.
All right. And you were asking questions of individuals in the bar to get an idea of what happened, right?
Yes.
And you were informed that Mr. Vasquez was trying to intervene and stop a fight? Is that what was reported to you?
That's what I recall.
All right, no further questions.
Okay, thank you. Any redirect?
Nothing, Judge. Thank you.
Thank you, Susan, step down. All right, counsel, just from off record, okay. Ladies and gentlemen, I was just confirming the remaining schedule with the parties. The witnesses that need to testify are not yet available today. We have them scheduled for 9 a.m. in the morning, and the witnesses will be called, witness or witnesses will be called, and then you will have closing arguments of counsel and instructions of the law. As it's laid out with the constant conversation with the parties, the case will be with you sometime tomorrow after lunch or shortly thereafter. So what I ask for you is to go ahead and prepare for such a schedule. If you'd like to bring an extra snack with you or a beverage with you or something like that you'd like to have in the afternoon. Once the case is turned over to you, the schedule then be surrounded or consistent with what you are in desire. If you need a break, we'll give you a break. If you want to keep working, you'll keep working. If you need some food or something like that, we'll give you the opportunity to get food. So once we have the case to you, the schedule becomes in control of yourselves. With that, we're going to excuse you, remind you of admonitions about not reading anything about this case, not investigating anything about trial practice or this type of a case or anything like that. No medical research. Please do not go on to Twitter or Facebook and talk about your experiences thus far. You'll be freed up from that restriction soon enough. As well as please don't try to research anything on your personal research devices. All right, excuse me.
All rise for the jury.
Seated. Counsel, we are going to have yourself stay. We do have some more legal work to take care of the arguments, picking up as we left off yesterday. A couple other issues to cover, and that will be on record. So I don't have to have a full complement of court security. Does either side have the objection to having the audience excused while we do that?
No objection.
None from the state.
All right. Ladies and gentlemen in the audience, I know you've been very curious about everything that's going on and attentive. The next part that we're dealing with is all legal argument, and I'm not sure what the schedule is going to be. There's going to be some research time in here, and that will be related to the jury instructions and the rest of the schedule. So I'm just asking if you don't absolutely need to be here, that you go ahead and leave for the evening. If you stay, I have to have more court security in the courtroom, and that is something I would have to work out with our chief of security. All right, so we're in recess for the day. You're welcome to come on the way. If that was anything I need to know about.
What's that? I'm sorry.